Thank you all for coming. Today's proceedings. My name is Shane Blundell. I'm an Assistant Attorney General in the Attorney General's office. I'm in the Policy and Government Division. Seated to my left is Barbara D'Souza, also from the Fair Labor Division of the Attorney General's office. On behalf of the Attorney General, I want to thank you all for your time, energy, and commitment for showing up today on this hearing on earned sick time. Just for the record, that's 940 CMR 33, notice of which was published on May 8th. Just want to have a few opening remarks. So an important part of making good law and good regulation is that we have an opportunity to hear the perspectives from all the people that could be affected by the proposed regulations. And then we are familiar with the fact that there is a great deal of passion and interest on this topic, on earned sick time. We applaud your passion and willingness, and thank you for coming today. And just for us to understand clearly the concerns you all may have about these regulations, you'll see through the course of the day, we, Barbara and myself, may ask some questions to try to make sure that we understand how the concerns articulated are tied to the language of the regulations. And as you hear these questions, just please understand that they have a purpose, which is to make sure we can do our jobs in promulgating regulations that address or at least accommodate or acknowledge the concerns that are raised. We have microphones here. They're for amplification, I think, but they are recording today's proceedings, so please just speak in a normal tone of voice. And again, just because it is being recorded, it's the recording today, anything you say will be subject to the Public Records Law. We have some notices here just to remind folks, but we just want to make sure people are aware of that. So as you may have seen already, Tim and Allison are out back. They're signing people in. They have copies of the regulations. They have copies of some frequently asked questions, some other information about the law, about the regulations, and can kind of answer any kind of questions about some of the process today. We have a sign-in sheet, and hopefully you have signed in. And if you do want to give some testimony today, there is a box you can check. So we'd appreciate that. If you do not want to provide some comments in the hearing today, there's venues to provide some written comments. We have a box. We also have an email address. It's AGO regulations at state.ma.us. Once again, that's AGO regulations at state.ma.us. Sorry? So AGO, so like Attorney General's Office, regulations, all one word, and then at state.ma.us. But certainly we welcome any comments people have today, but we have received a lot of comments already through email, even through the old-fashioned snail mail. So, and we have obviously a great deal of interest today, and so thank you again. We are going to try and limit folks to about 5 minutes, just respectful of everybody's time here today. I'll have a little timer here, so you'll just want to make folks aware of that. And I think what I'll try and do is we have the list here from Tim and Allison, from all the folks that have signed in, and the process will be we'll call people up and we can go from there. I do want to acknowledge, I think we have Representative Farley Bouvier, if she would like to give some comments. Thank you.
Good morning, and thank you for coming to the Berkshires. Doing the hearings around the state is no small task. I can see your whole team is here. Having public hearings is those in themselves are regulated, and being able to adhere to all those regulations is no little thing. Are we on? There you go. Now? Okay. Thank you, everybody. So I'm going to start by saying I don't like initiative petitions. I don't think they're a good way to govern. But after many, many years of advocacy around earned paid sick time, the advocates for earned paid sick time felt they had no other choice but to go to the initiative petition process because the parties could not come together. Because it was an initiative petition, the whole law was written by only one side of the argument, right? That's how initiative petitions are. They've happened in the past. It happened around medical marijuana. We're still, in trouble around that one. This, however, did go to the ballot. It passed overwhelmingly by the citizens of Massachusetts that earned paid sick time was long overdue. So now our challenge is the regulations around it. It's messy, it's complicated, and the people that you see here in the room are real experts at this. And so it's terrific that they're here. You can see that even in the Berkshires, we have businesses who care about this. We have workers who care about this. And so, again, I thank you for making the time to come all the way out here. Earned paid sick time. This issue disproportionately affects women. It disproportionately affects minorities, the poor, the low-wage worker, and people who have multiple part-time jobs. These are our most vulnerable. And this law has to be implemented, and we need to protect these workers. That being said, businesses in the Berkshires and across the Commonwealth have real concerns about the implementation, have real concerns about the regulations, and you listening to them about how we can do it better is going to make this law work for everybody. So again, I appreciate you being here. When you are putting this whole thing together, you're going to hear about the cost to business. That's very important. We need to be sensitive to that. But we also need to be sensitive to the cost to the worker. What is it going to mean to a family if this is delayed? What is it going to mean to the collective workers? What is that cost going to be? And so we can't just balance, we can't just talk about the cost to the businesses, we have to balance it out to the cost of the workers. And so when it comes to this, I'm asking you, do not delay implementing this law, especially when it comes to workers being able to accrue this time. If we have to delay the penalty phase, if we have to delay, when the paperwork has to get in, all those are the things I trust the experts to work together with you to make this happen. But do not delay the accruing of this earned sick time. The workers of Massachusetts deserve that we get this thing started. 2/3 of the citizens of Massachusetts said yes to earned paid sick time, and we need to make sure that this gets implemented. I'm really looking forward to the conclusions that you all come up with after listening to people across the Commonwealth on this, and as the legislature are waiting truly for the conclusions that you come to and the recommendations that you make to us to see if we need to make any changes legislatively. So I thank you for your time, and I'm sorry that I'm not able to stay to hear further testimony.
Thank you, Representative. First up, we have Brian Morrison.
Good morning. I'm Brian Morrison, and I represent the Berkshire Central Labor Council, Mass AFL-CIO. And I, too, thank you folks for coming out here. I've had to make the drive the other way lots of times, so it's a nice ride, isn't it?
Yes, thank you.
Just try it in January. Okay. I just have a few points. Nearly 1 million hardworking people in Massachusetts, almost 1/3 of our workers, can't take a single paid sick day and risk losing their job if they have to stay home to care for themselves or for a sick child. They shouldn't have to make this choice. These workers are often forced to choose between going to work sick or losing a day's pay. They send their kids to school sick because they can't afford to take a day off to care for them. This can't continue. The Attorney General has developed a fair and balanced regulations implementing the ballot question that was passed overwhelmingly by the voters last year that also support responsible businesses that already provide sick time for the workers. Our goals were always to provide earned sick time for working families that don't have it now and protect workers from retaliation when they need to care for themselves or a loved one. And the Attorney General's regulations capture both the letter and the spirit of the ballot question and ensure full implementation of the law on January 1. This law gives workers the right to start earning their sick time beginning July 1, and nothing should stand in the way of that. Denying them the ability to do so violates the will of the voters of Massachusetts. Last year, a majority of the voters across the Commonwealth voted to provide sick time to 1 million workers, once again placing our laws in step with our people's values. And we're grateful for the Attorney General for moving forward and for you folks coming out. That's all I have. Okay.
Thank you.
Thank you.
Next up, I have Theresa Dagno? Sorry?
That's all right,
Dano.
I am Theresa Dana, and I am with Adams Plumbing and Heating in Adams, Mass. We are a construction industry and do a blend of public prevailing wage work and private non-prevailing wage work. Currently, our employees earn a base wage when on private work or sick, holiday, or vacation time, which also includes fringe benefits where our business is paying for 100% of their health insurance. In addition, we give a 9% profit-sharing contribution on those wages, something that is unheard of in the Commonwealth. When employees earn different pay rates under this current legislation, it calls for sick time to be based on the prior week's earnings. For our employees who are working on prevailing wage work, their wage rate is much higher, and the package is computed and set due in part to the fact that they do not get paid time off, sick, or vacation. This higher rate is then going to be the pay rate basis for their sick time, plus be eligible for the 9% profit-sharing contribution and our health insurance payment that we make for them. We maintain that sick pay should not be computed on the prior week's pay, but on the employee's standard rate of pay. We also work hard to take on, and in many instances, provide the schooling necessary to train apprentices in the trade. There are strict ratios of journeymen to apprentices, and if a journeyman calls in sick, it could mean that the apprentice cannot work that day. Historically, we have given 2 sick days per year, in addition to 8 paid holidays and 2 weeks vacation. Most employees are sick and use their 2 days. We anticipate that they will be sick more often and use all 5 days. Additionally, we anticipate that many will be sick on the Friday before and/or Monday after a long holiday weekend. This will be very disruptive to our construction schedules, especially during the summer months, which is our peak work season. With our workforce of an average of 95 employees, this equates to 2 full-time employees being paid and provided with health insurance for doing nothing all year long. Each business has its own set of challenges to meet and deal with to continue to provide jobs in our tenuous economic environment. Fringe benefits, including paid sick time, should be at the discretion of each employer. Under current federal law, the FMLA, employees are protected and allowed to take up to 12 weeks of time off for the same reasons as outlawed in this legislation. It is apparent that our legislators recognize the economic burden that this law places on employers. This is very evident by the wording, employees of a particular city and town are covered only if or by appropriation of sufficient funds to pay for the benefit. Why should this burden be forced onto private business who not only provide jobs to the citizens of the Commonwealth, but also provide and pay tax revenues which funds the Commonwealth and these municipalities? This question was placed on the ballot because the legislators were not willing to do what they knew was right. They were afraid to vote no. I guarantee you that if you put a question on the ballot that each working person in the Commonwealth should be given $1,000 a year by the Commonwealth to cover sick time, that would have easily passed as well. But as we all know, that is not financially sound or feasible for our state. Instead, it has been pushed off onto the private employers. This law will not help bring businesses to our Commonwealth, and it puts an undue burden on those that are here. The cost to the worker is going to be less jobs or reduced benefits to compensate for the added expense.
Next, I have Arthur Milano.
Good morning, and thank you for coming out to the Berkshires. We appreciate that. I am the Vice President for Human Resources at Berkshire Health Systems, which is just less than a mile down the road. And I think what I want to talk about is probably slightly different from what you may hear from some others. First of all, I think this law is probably a good thing. It's probably a good thing, great intent, take care of those workers that Mr. Morrison mentioned a few minutes ago. But I think it's gone astray, and that's because of the way it was written. So let me talk about two aspects of this. The first aspect is paid time off programs. We enjoy an earned time program at our health system. It is a very, very good program for people. They love it. It would be very easy, the way this law is written, for us to work with this in a way that basically people lose certain abilities in their earned time program. Whereas now, every hour in the work time program is subject to cash. People can take cash in lieu of taking time off when they choose to do it, when their family needs or personal needs require a few extra dollars. If you take these hours and put them in this separate mass sick time bank, then we won't necessarily be able to do that. The easy way for us to deal with it would be to just put it over there, reduce the number of earned time days, and you know what? Our people won't like that. So we're trying to figure out now, we're wrestling with all the different aspects of this law. I know the regulations haven't been written, so I hope that when you finalize regulations, you'll take into consideration more than you have already with the 6-month moratorium, paid time off programs and what kinds of things can be done for employers who have those paid time off programs so that they don't simply take things away from their employees and structure it the way the law requires. The second piece is notice. And this goes somewhat along the lines of the Adams Plumbing situation. Although I believe, and I know historically, that the vast majority of people will be prudent about the use of their sick time. But there will be some who may not be. And in a healthcare situation where we're staffing emergency rooms, we're staffing ICUs, and we're taking care of our friends, neighbors, relatives, family members, we need to be sure that people can't, in the middle part of the day, remember that they had a dentist appointment and leave for the remainder of the day. Things like that. So the notice period, I'm not clear right now on what the law intends in terms of what aspects of an employer's current notification policy can be utilized where the law mentions reasonable notice period. So I hope that that is the second thing you will consider in the regulations, is thinking about notice requirements so that employers can adequately staff and make sure that they don't have problems with that. Thank you.
Thank you. Next, I have Michael J. Carity.
Good morning, everyone. How's that? Can everybody hear me?
Can you just say your name, too? For
Michael J. Carity. I am the Director of Human Resources for Berkshire County ARC, and we are a nonprofit human service provider here in the Berkshires. We employ 670 people, and we take care of about the equal number of individuals with developmental disabilities as well as brain injury folks. What our biggest concern is, there's many aspects, and this is coming from my heart. I think everybody should have earned paid time, but I'm going to put my business hat on now, as everybody has done. And our largest concern is our per diems, because we can't survive without them. And in our world, it comes back to what Tricia said. There are many people here in Berkshire County that work multiple jobs. We have increased our pay rates for our per diems because there's no benefits with it. We currently have very generous earned time for all part-time staff, whether it's 2 hours, whatever. But the difficulty still lies with the per diems. We have to have maintained staffing ratios in all of our programs. We cannot go below our staffing ratios for the safety of individuals. So if employee A schedules a vacation day and a per diem employee B is scheduled to work, if they have earned sick time, they could call out an hour before under the current law, or the proposed law, I'm sorry. And now I got to get employee C in to cover it because I can't go below staffing ratios. So just a quick estimate for us last year with our payrolls, it would have cost us about $30,000, which is unfunded. We don't have the money. It's not appropriated in our contracts, et cetera, currently. So we've got to come up with some ways. There's a lot of record keeping also, and we can go on and on and on. But we would like somehow to try to solve this problem with you folks and work things out with some language that may be a little more appropriate for us in terms of our per diem needs. And I thank you for coming out to the Berkshires.
Thank you. I have Jennifer Atwater. Hi.
My name is Jennifer Atwater. I am Vice President of Operations for United Personnel Services. We are a staffing organization, temporary staffing organization. We have offices in Springfield, East Hampton, and Pittsfield. We employ anywhere from 700 to 1,000 people weekly in a variety of different positions. And like most of the folks, I echo the sentiment. Thank you for being here. I think that's pretty clear. Just a couple of points that I wanted to address. Notice, again, is the first one. We are in favor of the sick time law. We think that we have many people who do go without pay because a loved one is sick or they are sick just by the nature of the operation and the business that we have. I also respect the fact that there are wonderful companies out there, such as Adams and others, that have solid PTO programs that are going to suffer because of this potentially as well. It's the latitude in the law that is most of concern for me, when and how sick time can be taken without employers having the opportunity to create policies that are appropriate to their business needs is going to create an undue burden, particularly for those production environments, whether they're manufacturing, medical, or call center industries. For employees to be able to take as many as 40 hours in increments as small as 15 minutes, with documentation only required after 24 consecutive hours, opens the door to widespread abuse and as an excuse for sick time to cover other non-related absences. If we take a disciplinary route with these folks, we do risk wrongful terminations, we risk discrimination, we get ourselves wrapped up in MCAD, which is never a great place to be. So I do think that there needs to be some work around the notice. Also the clarity of documentation, and when that documentation is to be received. It's sort of open-ended at this point. We would recommend perhaps 5 business days, to get that documentation into an employer. The vast majority of our employees work on short-term intermittent job assignments, whose hours are variable and sometimes very unpredictable, similar to the per diem folks that were mentioned earlier. Due to the unique nature of temporary work, most staffing firms will know when an employee's assignment is scheduled to end. Most staffing firms, once they find out when an assignment is scheduled to end, will give advance notice to the employees who will be affected, simply out of respect to let them know that their position is being ended. Staffing firms undergo a reemployment process with the goal of being able to have an assignment lined up for the employee at the close when their assignment ends. If an employee decides not to seek another assignment, or if they take an assignment with another staffing firm, they could take up to 3 days paid time off without giving notice before ending their relationship with a staffing firm. This would not only circumvent the intent of the law, but it would lead staffing firms to reassess whether to give their employees advance notice if their assignment is going to be scheduled to end or not. We respectfully ask that the final regulations surrounding paid time be taken within the same pay period that the assignment ends and should be treated as unpaid leave unless the employee produces appropriate medical documentation. Thank you.
Thank you. Okay, next I have, I think, June from the Berkshire Chamber of Commerce. June.
Hello there, I'm June Roy Martin. I'm the Vice President of Member Services for the Berkshire Chamber of Commerce. The Berkshire Chamber of Commerce is the only regional chamber of commerce in Berkshire County, and we have about 1,000 members, and they represent all aspects of business and industry. I do want to say I'm a working mom and have worked, while I'm raising my kids. And so I know about trying to take time off when your kids are sick and when you're sick. And we all know as employers that sometimes people come to work and there's presenteeism. They come to work when they're sick because maybe they're not getting paid. And I know that's a burden. But what I want to say to you is that we need to think about the burden on the employers. Especially small businesses, and 75% of our membership are small businesses, and that's 50 employers or less. Many companies are burdened in Berkshire County in Massachusetts with taxes, with business costs, and this is only going to be an additional burden. I really think you need to listen to the employers about the burden that this is going to cause them. Employers are trying to do all kinds of things, creative things, to win the talent wars, to keep people working for them in Massachusetts. And you've heard about some of them, and I ask you to listen to even more and to help them. And by having this go through, this will be a burden that will harm the employers of Massachusetts. So please consider that. Thank you.
Thank you. Okay, I think I have a Janine Burt here. All right.
Good morning and thank you. My name is Janine Burt. I'm the Student Employment Manager at Williams College, just a little north of here in Williamstown. And actually, one of the pieces that I want to talk about is probably much different than what most of those here today plan to speak about. Overseeing student employment, we have a significant percentage, roughly half of our student body, who work limited hours on campus. And it's our position that voters last November, when they were advocating for this, didn't really think about student employees as part of the employment workforce. And so really what we're talking about is the fact that students, their primary relationship with the institution is not that of an employee, but that of a student. The college minimizes or limits the number of hours that students can work in order to support that primary relationship with the institution of being a student. Those earnings are generally part of their financial aid package, part of their financial aid award. And I think that it can't be ignored, the financial burden that you've already heard spoken about from a number of individuals in the room that will be placed on not only our institution but others for not only our student body that works, but particularly those who are federal work-study recipients, as those federal work-study dollars cannot be used to pay for sick leave. And certainly some institutions have a significant percentage of their student body who do receive those federal work-study funds. So the financial burden really cannot be overlooked in that case. The other piece that we also have at Williams is a fair number of temporary workers who often find themselves in a situation where they're working multiple positions with varying pay rates. And our students fall into that as well, because even though they're limited to maybe 8 to 10 hours per week, they may be piecing that together with 2, 3, or even 4 jobs with differing hours, differing rates of pay. So for both students, while we're advocating that student employees be excluded from this legislation, if they remain included, we'd like to have the way that their pay rates for sick leave are calculated considered in the same way that we would support it being for temporary workers, which is that it be done at the regular rate for the position in which they're calling out sick, as opposed to blended, average, weighted for the previous pay period. Use the current pay period, regular rate of pay in the position from which they are calling out sick. And I think the other piece that has come up specifically, not today in conversation, but certainly in other conversations and other writings with regard to this proposed legislation, is around faculty. And I know faculty are granted a tremendous amount of autonomy with virtually no tracking of time usage. It's really just made available to them to use as they need. So to add this piece for faculty creates, again, you've got financial burden associated with that that may or may not come to weigh the same and have the same effect as it does for temporary workers and student employees, but there's certainly the administrative piece associated with that, where you're now pushing a group of employees who really have no accountability for, if they're going to be away, they're going to be away, and they cover their courses, and now we're asking them to have this additional piece of responsibility with no real gain for them, as it's time they'd be able to take anyway and be compensated for as part of their contractual or other agreement and arrangement with the college. So in summary, really asking that student employees be considered very separately from the general employee population, as their relationship is very, very different in that it is academic in nature, not employment related as a primary. Asking that they actually be excluded from this legislation, and asking that if they remain, that they, like other temporary workers, have their rates calculated based on standard rates of pay in the current pay period for the position from which they call out sick. Thank you.
Thank you. Danielle Gonzalez.
Good morning.
Hi.
I hate to follow Janine. I'm also Danielle Gonzalez from the Assistant Director of HR at Williams College, really to reinforce the same messages and maybe add a little more light to some of those numbers. In our staffing population for students, as she mentioned, half the student body, that is as many as 1,200 and 1,300 students on the payroll at a given time. And there is that nature of their relationship primarily focused on academics, and that we limit that to no more than 10 hours per week for upperclassmen. So we would ask that they be perhaps exempt from this regulation. As she mentioned, we have several hundred temporary employees. We value those tremendously as part of our workforce, and see the great value in providing this benefit to them, and that they should have the opportunity to earn sick time. We would ask that that be not the blended rate calculation as proposed, that we could pay, as they have multiple jobs, the rate in which they called in sick for that particular job. I would also reinforce that our faculty have a very different relationship to the institution. The autonomy, the sabbatical leaves that are granted to them, that they see that particularly as tenured faculty have a different relationship to the institution, and that would see this as an additional burden of even asking them to track such leave. So thank you so much for your time and coming to the Berkshires.
Thank you. Pat Beggars?
Do you want written testimony here or?
I can take it.
Okay, I'm not going to read this whole thing.
Okay.
My name is Pat Beggars, and I'm owner and president of Onyx Specialty Papers, which is a specialty paper manufacturer located down in South Lee. Our paper machines run continuously 24 hours a day, up to 7 days a week, depending on our order backlog. We employ 155 people. A significant portion of those people are rotating shift workers, hourly workers that rotate shifts to operate our machines in our boiler house. Our average hourly pay rate is greater than $20 an hour. We have other wage and compensation benefits, including shift differential, paid holidays, paid vacation, and overtime pay beyond that required by state and federal law. In addition to excellent wages, we offer our associates a very good benefit package that includes the medical, dental, paid short-term disability. We also offer 5 days of paid personal time that's given to each employee January 1 for them to use as they see fit. This program has been in place for as long as I've been at this location, which is 17 years, and it works very well. The continuous nature of our operation requires unique time management strategies to ensure that we balance the needs of the employee requesting the time off, the impact on coworkers that will be required to work extended shifts to cover for the absent employee, and the business requirement to keep the machines running smoothly and safely. We have developed and refined our attendance, call-in, and paid time off policies over the course of 20-plus years to ensure that we achieve that balance. We have a logical and well-functioning system that works for our associates while allowing us to operate continuously to meet the customer's needs. It does provide 40 hours of paid personal leave that people can use for the circumstances outlined in the earned sick leave legislation, but they can also use it for scheduled time off. Some of the provisions in this proposed regulation, as it is written, are potentially disruptive, not only to the business, but to the employees themselves. When this ballot initiative was passed last November, I was actually surprised by the response of our hourly shift workers. They were very concerned about the disruption that this would cause them by eliminating a lot of the notice requirements that currently exist, by employees abusing the policy. That was going to result in them having to work extended shifts. Our business is such that an employee cannot leave their station until they're relieved by an individual that's been trained to do that job. So when somebody calls in last minute, the person that is there is stuck working longer. It also means we also have a fair number of spares, so we try when somebody calls in sick to get one of those spares in. Well, that means we're calling people in who thought they were going to have the day off, and now they don't. We have developed rules and policies and regulations that have brought that all into balance, and I'm concerned that the way the regulation is written will challenge that. There are a couple of things I wanted to specifically call out. I think it would be very advantageous for us to allow employees to choose how they use their personal paid time. They have the allocation of the 5 personal days. Let them use it. They use it now for paid sick time, but they can also reserve it for other times. And if they choose not to use it to cover a day sick, then they would be subject to our attendance policy, and they would understand that. I'd also like to point out that for manufacturers that are operating rotating shifts, I'd like to request that we allow those employers like myself to require that paid sick time be taken in full shift increments. Allowing employees to take just an hour here or there is going to create attendance and tardiness issues, and that's going to negatively impact their coworkers. And then the third thing that I really just wanted to point out, which has also been mentioned, is we need more latitude to protect against abuse around call-ins around holidays. We actually pay employees for holidays that were shut down. But one of the rules we've had for years, and it was put in place because there was some abuse, was that if you call in sick the day before or the day after the holiday, you don't get the holiday pay. Now, I understand the sick law regulation would say you got to pay them for the sick day, and I'm okay with that, but I shouldn't have to provide them an additional benefit without them providing a note from the doctor, and that's what they do, and if they provide the note from the doctor, they get the holiday pay. Attendance issues are the biggest challenge that we face in operating our paper mill every day. We've developed compensation and benefit programs that we hope keep people motivated to come to work on time when they're scheduled to work. We've developed fair and reasonable policies that address attendance issues to prevent abuse in order to protect coworkers and the business from the negative effects of high levels of absenteeism. At the same time, we counsel employees with attendance issues and provide support and resources, including paid time off, to address medical issues. I strongly urge you to consider giving manufacturers who operate rotating shifts more flexibility in implementing this law. And I would appreciate any consideration you would give to that. Thank you.
Thank you. So I don't think I have anybody else here who's checked off their name. But if there's anybody I missed or anybody who would like to give some comments today, I would certainly welcome that. Ma'am?
Hi, thank you. My name is Cindy Ruffley. I am the center manager and also the human resource representative for Hamilton Relay. We are a call center that is located in Pittsfield. We process calls for the deaf and the hard of hearing. We had a couple clarification items, I guess you could say, regarding the legislation, things that have already been brought up this morning, such as the notification requirement. Also, the documentation doesn't seem to be specific. We have several part-time employees who work 4, 5, and 6-hour shifts. So in the legislation, it specifies that they have 24 hours of, was it 24 hours of time? 3 days or 24 hours, I think it said, meaning shift times. So if we have 5-hour shift people, that means they have 5 days or more to turn in the documentation. The challenge that we see is the law states that we have to pay them, even if they haven't brought the documentation until they do. So what happens if they never bring in the documentation? We've already paid them the sick time. That was one question we had. We have, like most employers have stated here, we have a generous wage package to kind of compensate for those individuals that might need time. We've always allowed time, as for the Massachusetts acts and also the Family Leave Act. We just need some clarification about how do we process this for those part-time people that work 4, 5, and 6-hour shifts. And we need to be more specific on the notification to the employer as far as call-outs. And also, how long do we have to wait for that documentation before we say, well, you didn't bring the documentation, and why do we have to pay them until they bring it in? So, thank you for your time.
Thank you. Once again, I open it up to the floor. If there's anybody else here who has any comments that they, sir. Oh. Okay.
Morning.
Hello.
Tom Swift, Housatonic Curtain Company. And I would like to know that there would be further clarification in the law regarding what is possible as far as attendance rewards. We have used attendance rewards for 20 years very effectively in our company. It's a manufacturing company. We need people in their position. But it appears that attendance rewards would cause adverse, would be adverse and would look as they are adverse for against people who are not getting the award. So I'm not sure how the regulation will end up, but we would like some kind of wording as far as rewarding people on good attendance. Thank you.
Thanks. Were there any other? Okay, ma'am.
Good morning. I'm Ruth Hanley, and I'm the Human Resource Manager at Riverbrook Residence in Stockbridge. And we are a group home for women with developmental disabilities. And we are a nonprofit agency, all female run. And we are in agreement with this law, but I wanted to say that I totally agree with the Human Resource Director of BARC that we need some clarification around the whole relief staff piece. Relief staff are so important to our organization, but it's just the nature of the business that they have no regular hours at our agency. We call them in if someone calls out sick or if someone has a vacation scheduled. So what will happen with this new law is someone will submit a time off request. I will get a relief staff to cover that shift. You know, a couple hours before that relief staff could call out sick. So then I'm paying the regular staff who asked for the day off. I'm paying the relief staff, and then I'm scrambling to find another relief staff to cover it. So, and I know that we actually share some relief staff with Berkshire County ARC. So I think we're just looking for some clarification around the whole per diem piece. Thank you.
Were there any other folks, ma'am?
Good morning.
Hi.
Hi. My name is Kathy Murphy, and I'm the Director of HR for Beckett Chimney Corners YMCA. And my issue is very similar to the Williams College issue that was mentioned, which is we work with over 350 seasonal, basically teens, and we work with them in order to give them life skills over the summer where they're counselors. We recently received a minimum wage exemption in the law for these counselors, which was wonderful from an economical standpoint. The concern I have is we file for a seasonal waiver every year that we get granted pretty much every year because of the fact that we increase our business between June 15th and August 31st. And because we hire 350 seasonal workers, we have to track and also provide information to every one of those young adults who at times can be challenging even getting them to fill out their new hire paperwork, to be honest with you. So to give them a law that's as long as this that they need to understand when we already pay them as part of the minimum wage exempt is going to be a challenge. In addition to that, the piece that has not been mentioned this morning is the break-in service, where if you return back to the organization within a year, you have to give that person that time, is also going to be a challenge. And the reason I say that is because they would get that time anyways from us because of the minimum wage exempt. So I request that if it is at all possible to exempt folks that get seasonal exemptions, because we already pretty much do that as part of the reduced wages that we pay for minimum wage. I also want to mention the PTO TOPE issue, which I also think is an issue. We provide an exorbitant amount of benefits to our employees. Being new to the organization, I get 36 days that I can take off a year. I can't even imagine taking 36 days off in a year with the job that I have to do. However, I use it for anything I want, and the reason we get TOPE and PTO, in my opinion, is so that we can control how we use that time. So I ask that we look when we're actually writing this to give the employee the ability to use it in any way they want, meaning that if they're not sick, they can still use it, and we'd get signed off documentation or whatnot, but it will assist us when it comes to managing our business, especially when it comes to cost. So thank you for coming out to the Berkshires.
Thank you. If there is anybody else who wanted to come before us today? Yeah. Okay, well, if you, do you want to, all right.
My name is Suzanne Wickham, and I own a payroll company in Berkshire County.
I have about 350 clients, and most of them are small businesses. I've had a couple of questions from my clients that we need just clarification on. A lot of my clients are restaurants. They're tipped employees. They normally do not receive any kind of time benefit. How would we handle tipped employees? Most of them make below minimum wage because we're adding the tips to it. How do we pay them? We don't know for the paid time off. Tips can vary depending on season. They make a lot more money in the summer. So I have a question on that. I don't have any kind of statement, but I just need clarification on that. And I have a lot of employers that are on the cusp, meaning they have between 9 and 13 employees and they waiver. All right, I've had one particular client that he's at 10. He's an S Corp. Can he exclude himself from this? He's not a sole proprietor, so he does get an actual paycheck, but he doesn't want to be counted in the count because he'll never take that benefit. So it's more of a question than a statement. There's so many variables in this that we don't know how to handle it. That's it.
Thank you. I think there was a hand in the back. Thanks.
Hi, and thank you for the opportunity to present our cases here, I guess. So my name is Lisa Delilah. I'm from Mayhew Steel Products. We're located in Turners Falls. We are a manufacturing company, and like lots of the other employers here, we offer a very generous compensation and benefit package to our employees, which already includes plenty of time to cover their sick leave. Our concerns are that the way our policies are written, we require employees to use sick leave when they're on FMLA leave. And my understanding of the regulations are that we will not be allowed to do that, require that. So our employees, historically, not all of them, we have some really good employees and we have some employees who find any way they can to get additional time off. So there is a lot of abuse with FMLA and sick time already. And I'm just hoping that when the final regulations come out, there's some clarification and thought process put in regarding allowing sick time to be used for FMLA. And as with the others, we use a lot of temp employees, and I am concerned with the requirements for how we're going to give them sick time when they move from one company to another to another. Thank you.
Just once again, ma'am.
Hi, my name is Kathymanship. I'm the business manager at the Berkshire Music School, a small nonprofit business here in the city. Most of my concerns have been addressed. However, due to the uniqueness of our business, we contract our faculty to be paid dependent upon enrollment. We're a tuition-based organization. If we have always allowed our faculty to take time off, unfortunately it was unpaid, but now if we have to pay them for sick time, nobody can, they have to teach the hours that they're contracted for. And so if they miss time, and then I have to pay them for that time, and then they have to make up that time, which is student-based. They would have to make up the lessons to the student. I'm now paying them again. So pretty much I would be paying them for their contracted hours plus paying them for sick time, which is going to add to our bottom line. And being a small nonprofit, always in a deficit, that's going to greatly impact us. We're going to have to add that to our budget, and it's almost like, well, I shouldn't say vacation, but it's still added paid time for income that is not coming into the business, and that's pretty much my concern with that. Thank you.
Thanks. Oh, ma'am.
Good morning. I'm Lois Hobbs. I'm the Director of Human Resources at the Breen Center. We serve people who have mental health and substance use disorders. We have over 450 employees. We serve over 10,000 people a year. And I just want to reiterate something that a couple of people have already said regarding per diem employees, because a person chooses to be per diem because they want or need flexibility in their schedule for whatever reason, so they can't commit to a regular schedule. We have plenty of schedules available for them if they'd like them, but they really do not commit to anything. So in a lot of cases, they are paid a higher rate of pay because of that, because they don't get benefits. And it's really difficult to give somebody a paid day off when they don't have a regular schedule. So I think what we're asking for is to exempt that group of people and have the law say that it's regularly scheduled employees. Because, like I say, it really does present difficulty for anybody who operates with that type of a workforce. That's it.
Okay, thank you. I'll turn it over again as if there's anybody else here who has would like to make some comment.
Good morning. My name is Lori Riopelle. I'm the payroll manager for Craning Company. And I thank you for being here and allowing us to ask questions. First, I'd like to say that Craning Company, as of January 1st, 2014, gave all of their employees an extra 5 days of vacation to compensate for the fact that previously we had no sick pay policy. So everyone got an extra 5 days to use as one bank as they saw fit. So this new law will add an administrative burden to a benefit that we already offer. Second, there's some vagueness in the regulations about the increment of time. One meeting I went to said that you have to allow sick time in any increment that your payroll system will allow, while our payroll system keeps track of time by the minute. So what is my protection of those employees who decide to call in sick 10 minutes every day to take care of their child? How does that affect the other coworkers now who have to pick up the slack? We're a manufacturing business that runs 24/7. We have very specific absentee and call-in policies to protect the safety of our workforce. My second question has to do with, currently we all have, it's one bank, one PTO bank, which includes our exempt employees. So as other businesses have mentioned, this would add an administrative burden to our exempt force to keep track of time that they already have. So it's an extra burden without an extra benefit. My third question has to do with the regulation of carrying over 16 hours to the next year. All of our employees on January 1st of each year are given 40 hours, even our new hires, on the first of the year. So what incentive is there to carry over 16 hours from the previous year when by law, they'll never be able to use the 56 hours? Our employees are paid off all of their unused PTO time towards the end of December. They want this cash. They do not want us carrying over 16 hours. They want to spend their money on their Christmas presents. My last concern is interns, work study, and co-op students. We as a company have this benefit of having our employees' kids come in and learn a trade. So we're already paying them a fair hourly rate, probably better than they could get at most summer jobs in this area. And we're also have the cost of training them. So our staff is slowed down a little bit to offer the benefit of them learning. So to make us pay them sick time as well may force us into a situation where we decide we can't offer that program anymore. Thank you.
Thank you. If there's anybody else here today that wanted to make a comment or present a question. Well, if there's nothing more, I think it's 11 o'clock. We're here till 1. If there's any further interest, I think until then, we're going to suspend the hearing.